I have been trying to parse this out in a similar way to Justice Thomas, but let me just give you a certain number of hypotheticals and tell me when it becomes private and when it's still public. A teacher begins each of her classes with a silent prayer and an audible prayer. Now, when I say begin, bell rings, students are coming in, they sit down, teacher says the prayer privately or publicly. Is that within her duties as a teacher?
I would think so, Justice Sotomayor.
Why?
Because it's during instructional time, it's during a time where she has instructional
How about
duties.
before the bell rings? Students are coming in, she's reading the Bible. She's reading it out loud. Before the bell. Is it the bell that makes it within the time or not within the time?
Well, I would say the bell is what makes your first hypothetical a relatively straightforward one. As to your second hypotheticals, because I think there's two things there. I think if the teacher were before the bell reading her Bible at her desk, either silently or barely audibly, that would be private speech, that would be protected. If before the bell, but while the students are all there, she's reading out loud to the class, I think that's kind of the edge case, because
so let's take it to the end of the class. The students are getting up. It is part of everyday life that as students leave, they stop and they talk to the teacher. She gives them some answers to their questions about the lesson. But instead of doing that, instead of waiting for those questions, she decides, I'm going to say a prayer. Is that within her duties is that personal, or is that still something that will be perceived as part of her workday?
So, Justice Sotomayor, I think that's closer to the edge case, and I think what it would depend on, again, first of all, if after the bell rings she's reading the Bible, because she's free to do whatever she wants, and she chooses to read the Bible, and she does it either silently—
But she's not free to do everything she wants. She's required, as part of her duties, to be available to the students and answer their questions.
Well, then it might be a situation where in that hypothetical, where she's essentially supposed to be continuing to have some instructional obligations to the kids, and she's not free to text her spouse, check her email.
Well, let's take that, okay? She's not free to do that because it's personal. She could do it, but it's personal speech, not religious speech, to text her husband or to check the internet. Could she be fired for texting her husband during school hours?
Well, I think if I'm understanding the hypo right, if it's a neutral rule, doesn't single out religious expression.
No neutral rule. This is, if she does something that's private on office hours, this is her employer. Her employer says to her, don't do private things when you're working. And she does it anyway. Can she be fired?
So that is a neutral rule, as you're explaining it to me. I think that's important to my answer. So I just want to make sure that's common ground. It's a neutral rule that you can't do anything private.
But why does it have to be a neutral rule? Meaning, and this is why I'm getting to this example. She's on duty. She's on duty in the classroom. And the duty is not from the beginning of the bell to the end of the bell. The duty is while she's in the classroom. So why can't an employer tell an employee what they're permitted to do, personal or otherwise, during that time? And I ask this question because I'm analogizing it to this situation. I found it odd in your brief that you just kept saying the coach wasn't on the field during the game. But I have a dozen or more statements by your coach telling and admitting that his duties as coach weren't just during the game. He had an obligation to remain behind for 2 hours after the game finished. That was part of his duties. He had a duty to make sure that he escorted all the players off the field. He had a duty to make sure the other team got off the field. He had a duty to do a post-game wrap-up, both with the players and the coach. He had a duty to clean up and to make sure that the gym was left in good order. So I guess what I'm asking is, if he had all these duties and your employer says to you, these are the duties that you have, and that's all I want you to do, why can't it choose to say, and the one duty I don't want you to do is to do this one because you are an example to your players. You admit that that's part of your duties. If it's not part of his duties to set the example the school wants, why can't the school fire a coach who decides to put a Nazi swastika on their arm and go to the middle of the field and pray? If someone comes up and says, that's part of my religion, could the school say no to them?
So, Justice Sotomayor, I think there were maybe 3 different hypotheticals there, and I'm going to try to deal with them as best I can. If somebody wants to have sort of a Nazi emblem, but it's not religious.
Assume it's religious.
But if it's not religious.
Assume it's religious.
I'm happy to assume it's religious. If it's religious, that might be, if it's claimed to be religious, that might be one of the rare cases where you question the sincerity of the religious belief, because I'm not really aware of that religion myself. But assuming it's a sincere religious belief, there's no basis to discriminate on the basis of religion. And so the school might have to address that through a neutral policy, avoiding disruption. And if it's a neutral policy and doesn't single it out because it's religious, then that's something that would be evaluated under Pickering.
Mr. Clement, can I?